This case starts like many others. But what unfolds in this courtroom is something far deeper than just another sentencing. We're looking at a man with a long history of drug offenses, repeated chances at rehabilitation, and a system that's clearly running out of patience. The prosecution wants prison. The defense is begging for treatment. And the defendant, he claims he's finally ready to change. But here's the real question. How many chances is too many? And at what point does the court stop believing promises and start enforcing consequences? Stay with us, because this judge is about to lay everything out, and it gets brutally real.
State of Ohio versus Robert Keegan. Mr. Keegan is before the court with his counsel, Mr. Clark. Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. Ms. Nicholson, anything on behalf of the state?
Your Honor, at this time we're asking that the court sentence Mr. Keegan to prison. The court is well aware of his history. I believe he's had at least 5 prison sentences. I'm not sure he's ever successfully completed any supervision. He's had multiple cases before this court, and he was purportedly in treatment at the time that this possession occurred in June of last year. He has 49 days of jail time credit, and we are requesting a $250 reimbursement
Right
to
away,
the Lebanon
the
Police
prosecution
Department.
sets the tone end. It's not looking good for the defendant. When you hear phrases like 5 prior prison sentences and never successfully completed supervision, that's a massive red flag in any courtroom. Judges rely heavily on patterns of behavior, and what the state is in here is a consistent cycle of release and relapse. Now, the request for prison isn't just about punishment it's about public safety and accountability. And that $250 reimbursement, that's standard, but honestly, it's the least of his problems right now. Let me ask you this. If someone keeps repeating the same offense over and over, should the system keep offering help or start drawing a hard line?
From probation. Mr. Clark?
Your Honor, my understanding is the primary recommendation was what the state already advised the court. However, I believe there was a secondary recommendation, an alternate option, which would be more treatment focused. It's clear that he needs rehabilitation. I understand the court may not want to exhaust those types of resources, but those resources are designed to help people like Mr. Keegan. He does need treatment, and even if that's inpatient treatment or something to assure the court that he won't abscond, I think he needs that, and I think he's willing to take it seriously this time, Your Honor.
I definitely feel that, treatment is something that I could benefit from. There was a point in time that I probably would never even ask for it, but I think I'm close to turning the corner and potentially staying sober. And I think I could do probation, or I wouldn't even ask for the opportunity.
Your Honor, just a few other things. I did want to note that the defendant's girlfriend and mother in the back of the courtroom as well in support of him. And wasn't there an issue of you taking methadone and not having that available while in prison? And I want to discuss that.
No, just not prison. The CBCF wasn't safe. There's no CBCF. So
okay. And how long have you been on that?
18 months.
Okay. Nothing further.
I didn't catch what all of that covers.
He's been on methadone for several, over a year.
It didn't prevent him from using heroin here. That's not good. If you're on a...
This is where things take a serious turn. The defendant is arguing for treatment, saying he's ready to change, but the judge immediately zeroes in on something critical: the methadone treatment. Methadone is supposed to help people stabilize and reduce opioid use, but in this case, the judge points out a harsh reality. He's still using heroin despite being on treatment. And then comes the most shocking part. Narcan used 5, maybe 10 times. That means multiple overdoses, multiple death experiences, and still no lasting change. From a legal standpoint, this is devastating for his case. It shows not just addiction, but effectiveness of prior interventions. So here's the big question. If even near-death experiences aren't enough to stop someone, what will be?
If you're on a medication that's trying to prevent you from using, and you're still using, Narcan's been used on you how many times? That's a question.
Several.
You don't even have a number?
5, 10 maybe.
5 or 10 times you've overdosed and Narcan was needed to revive you? You say you can't do a CBCF because why?
No, they don't accept methadone.
I don't know what the methadone's doing for you because you're still using.
I mean, I think last year I was clean for several months. It was an improvement and a big step in the right direction. I feel like compared to what I've done in the past when I've got out.
2008, burglary and theft. Ended up in prison. I'm just going to hit the highlights. It's 2009, trafficking in heroin, trafficking in marijuana. 2012, possession of heroin, possession of cocaine. 2014, possession of heroin. I'll skip the misdemeanor assaults and OVIs and otherwise low-level offenses. 2018, possession of drugs, felony. 2018, in front of me, possession of heroin. 2018, again in front of me, possession of fentanyl. 2020, in front of me, possession of LSD. 2022, in front of me, aggravated possession of drugs, methamphetamines. 2022, Montgomery County, felony OVI. You're currently on active probation in Miamisburg, and it's my understanding that
What the judge just did here is absolutely critical. He laid out the defendant's entire criminal timeline. The voice you selected does not support this language. Please click the upper right corner to switch to another voice. Stretching back over a decade with repeated drug-related offenses, this isn't just a bad decision or a one-time mistake. This is a pattern, deeply rooted in addiction and criminal behavior. And in the eyes of the court, patterns matter more than promises. Notice how the judge even skips minor offenses. That's because the major felonies alone are enough to justify a serious sentence. By this point, the courtroom isn't debating guilt or innocence anymore. It's deciding whether this individual is even for rehabilitation outside prison. Be honest after hearing that history. Do you think the judge still has a reason to trust him?
you had a 2025 Montgomery County case dismissed using the Good Samaritan law. Mr. Keegan, I have no doubt in my mind that you need serious drug help. And it's been offered to you. You apparently are implying that you don't want to do a CBCF because this Suboxone is so important to you. It's not working, but I'm not going to take a chance. You are until you get to the point where you seriously want help and want to end this lifestyle. I can throw all the treatment at you I want, and it's not going to work. So with all of that, the court is going to find today that you are not amenable to community control. Prison is necessary to fulfill the purposes and principles of sentencing. Unfortunately for you, it's mostly punishment. But I have no doubt that you need help, but I don't know what else I can do to get you to understand that this is going to kill you one day. To be Narcan that many times, to be brought back that many times, to me would be shocking enough that should shock you into, I don't know. I'm going to order you to serve 10 months in prison. You have 49 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control. Upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. I do wish you luck, and I hope you make some changes in the future. So seriously. Anything else, Ms. Nicholson?
No, Your Honor, thank you.
Mr.
Further, Your
All
Honor.
right, thank you.
Mr. Counselor?
In the end, the judge makes it clear this decision isn't just about punishment, it's about reality. Despite acknowledging that the defendant needs serious help, the court ultimately rules that he is not amenable to community control. That's a legal way of saying rehabilitation outside prison has failed. Repeatedly, the 10-month prison sentence reflects not just this offense, but years of repeated behavior, missed opportunities, and escalating to his own life. The mention of Narcan, overdoses, and failed treatment attempts paints a grim picture, one where the court feels prison is the only remaining option. This case highlights a powerful and uncomfortable truth about the justice system. Sometimes, help can't work until the person is truly ready to accept it.